Hi everybody, my name is Sarah Schickman. I'm a healthcare attorney, and I wanted to go over some of the most surprising laws about medical spas. Since there is no nationwide regulation on this newly emerging area, there are a lot of really surprising laws all around the country. And in this video, we're going to go over some of the most surprising ones in different states. What are the most 10 surprising medical spa laws that we have come across? Number one is about microneedling. So the first question is, what is microneedling? If you're not in the medical spa business, maybe you've never heard of microneedling. Microneedling typically is a procedure where a device is used to create micro injuries on the skin, and then those injuries stimulate collagen and they repair themselves and they make the skin texture better. It's usually done using a device, a medical device. Not one of those rollers that you see online on Amazon. So this device usually is operated by someone who can operate that in the state. So the question becomes, who can perform microneedling in different states? And the answer is pretty surprising. It totally varies depending on what state you're in. So for example, in New York, microneedling can only really be done by a physician assistant by delegation from this physician. As a nurse practitioner, you cannot normally do microneedling. That's a really surprising law to most people because in a lot of other states, a nurse practitioner can do microneedling no problem. So another question related to microneedling is it a medical procedure? Does it have to be done in a medical spa? Can it be done in a regular spa? And the answer is also very state specific. There's no nationwide regulation on microneedling. So that's just one of the 10 most surprising laws. Another really surprising law that has to do with medical spas is the regulation of laser hair removal. It is very different depending on the state. So for example, in New Jersey, technically a nurse practitioner is not able to do laser hair removal. She or he cannot operate laser hair removal equipment or any laser. In New Jersey, that is supposed to be done by a physician. Whereas in New York, that is considered not a medical procedure, and a lot of people who are not doctors are doing laser hair removal. So totally different laws in two neighboring states. Very, very different. Another procedure that comes to mind is Botox and fillers. So Botox and fillers in some states can only be done by a nurse practitioner, while in other states, they could also be done by a registered nurse. Very different. For example, in New York, a nurse practitioner or a registered nurse can administer Botox. But in New Jersey, a registered nurse cannot administer Botox in most situations. So two very different laws about the same procedure. So another topic is the corporate practice of medicine. Who can own a medical spa? This answer is very different depending on the state. So for example, in Florida, there are no specific laws prohibiting the corporate practice of medicine. However, the person who can be a medical director of a medical spa is really defined and specific. It cannot just be any doctor, any specialty. It has to be a board certified or board eligible plastic surgeon and dermatologist. And there's also a geographical limitation. In most states, that's not the case. So this other thing is also very much state specific. So you just have to make sure that whatever you're looking at is correct for your state and not just something that you read online. Another area that's very surprising about medical spa laws is telehealth. It is state specific. In some states, telehealth is allowed, and in other states, it's not. So whenever you're doing remote consultations, you have to make sure that they're okay with your state's laws. These days during the pandemic, a lot of states have adopted emergency orders that allow telehealth, but not every single state still has that today. And you just have to make sure that you check before performing telehealth. And then the other question that comes during telehealth is, when does the exam have to take place? Is it okay if, for example, a registered nurse sees a new patient and then afterward the provider or the prescriber sees the patient? In most cases, the answer is no. You can't do it that way. A good faith exam has to be performed before a registered nurse sees the patient. So, or you can't just assume that because you found some information online that says you can do it, that you can do it. It's not like that. Another topic is the prohibition on the corporate practice of medicine. And this varies state by state as well. Some states have a strong prohibition on it, and some states have no prohibition at all. For example, in New York, there's a strong prohibition on the corporate practice of medicine. And what does that mean? That means that business people should not be practicing medicine. And more specifically, they cannot be making any medical decisions or exercise any medical control. So what that means is an LLC, let's say two partners who are business people form an LLC, they cannot use that LLC to own a medical spa. The medical spa has to be owned by medical professionals in New York. There could be something called a management services agreement between medical professionals and business professionals, by which the business professionals will do the business administrative side of the practice. But all the medical decisions, anything remotely medical, has to be controlled and owned by the medical professionals in New York. But that's not the law in every state. Some states, you could have an LLC, and that LLC can outright own the medical spa, and it's no problem. So before starting a medical spa, it's really important to make sure that you're not surprised by one of these laws, because it's really difficult to restructure once you're already structured incorrectly. It's much easier to just structure correctly from the beginning. Another law that's surprising about lasers is lasers and ablative procedures. So for example, CO2 lasers or other ablative lasers. In a lot of states, there are laws that say only physicians can do these lasers. And people come to us all the time, they say, but I see down the street there's an esthetician doing it. And that's something that they're choosing to do, but that's not allowed. And what happens is if someone gets in trouble, you could never say, well, everybody else is doing it, so I thought it was legal. That's not a good defense. So for example, in a state like Alabama, ablative lasers are only to be used by a physician. So you just have to make sure to check your state's laws before purchasing this kind of equipment as well, because it could be a very expensive mistake if you end up with equipment that technically you can't use. Another surprising law is that some states don't even have laws about specific treatments. And that's because the laws came out way before these new treatments came out. One of these treatments is microneedling. So as of today, for example, in Vermont, there's no law that says that microneedling should be done by nurse practitioners or physicians or RNs. There's just no law on the books yet because the procedure is too new and there's nothing that says who can do it or not. So you just have to make sure that whatever procedures you're doing, let's say in your medical spa, you're doing 5 or 10 different ones, that you check for each one exactly who can prescribe it and who can administer it. And so that you're not surprised whenever a regulator comes in and asks you, okay, let me see the charts for these 10 clients, and you show it to them and they say, well, this person was not supposed to be seeing those people. There are also surprising laws about FDA approved and non-FDA approved treatments. In some states, they're regulated differently. So for example, in Washington state, the prescriber has to be on site when a non-FDA treatment is being performed, whereas the prescriber does not have to be on site when an FDA treatment is being performed. Another surprising medical spa law is about on-label and off-label treatments and FDA and non-FDA approved treatments. There's a difference in how those are regulated, and there's a big difference in liability for those. A lot of times in your medical malpractice policy for a medical spa, non-FDA approved treatments may not be covered. And sometimes even off-label treatments that are FDA approved, but not for the area in which you're doing, may not be covered. So it's surprising, but you have to make sure that you read your malpractice coverage policy or have your attorneys read it, because there may be stuff in it that's completely shocking, frankly, because you may think that all the procedures that you're doing in your spa are covered, but that may not be true. Here's a bonus surprising fact about medical spa laws, and that's the fact that in some states, medical malpractice insurance is not required. You may think that you need to have it, but legally in some states, like New York, you actually don't need to have medical malpractice coverage. We would strongly recommend that you have it. It's much better to have it. But that also means that a consumer, when they go to a medical spa, may be going to a place that actually doesn't have insurance, which is a much more dangerous place to go to. And so you have to educate the consumer and say, well, we here have a malpractice policy, and it's great if that's one of your differentiating factors. Again, it's not something you would probably bring up during the consultation, but it gives clients peace of mind knowing that your business is fully insured, because in some states, not all are. And it's surprising, but insurance is optional in some states. So I hope you enjoyed this summary of surprising medical spa laws. There are a lot more laws who are surprising. And if you guys have any questions, just reach out to us and we're happy to help. At the end of this video is a link to our website and our email, and we look forward to hearing from you. Thank you.